Okay, welcome back. We have next panel on FCPA trends and developments, and we have a great group with us here today. Let me start with our moderator, Joan McKown, a partner at Jones Day with more than 30 years of experience in SEC enforcement and financial regulatory matters. Prior to joining Jones Day, Joan was the longest serving chief counsel in the Division of Enforcement at the SEC. And among other things, I learned looking at her bio, oversaw the creation of the first version of the enforcement manual. Nice.
There you go.
Welcome, Joan.
Thank you, Bruce.
Charles Cain is our panelist from the SEC. We always love having Charles on this panel as he heads the FCPA unit in the enforcement division. Charles has been in the FCPA unit since its formation in 2010 and in the Division of Enforcement for nearly 20 years. Charles, great to have you with us to discuss FCPA issues. Thanks again for joining us.
Great to be here. Thanks for having me.
Very pleased to welcome back Tarek Helou, a partner in the Washington, D.C. office of Wilson Sonsini. Prior to joining that firm, Tarek spent 12 years at the Justice Department, where, among other things, he was assistant chief in the FCPA unit of the Criminal Division's fraud section. And he also previously served as an AUSA in the Northern District of California. Tarek, welcome to the panel and look forward to hearing your thoughts.
Thank you, Bruce.
And finally, very pleased to welcome back Bill White. I'm sorry. Yeah, Bill White, where'd he go? There he is.
Yeah.
Hey, Bill. Bill is a seasoned pro in the enforcement world and a partner at Allen and Overy. He also previously served in the enforcement division of the SEC for 8 years, including as a branch chief and as a senior trial counsel. Bill, thanks for being here and welcome.
Thanks, Bruce.
Let me turn it over to Joan. It's all yours.
Okay, thanks so much, Bruce.
Thanks.
To everyone, we're going to be doing a sort of a broad overview of the FCPA space today, and it'll be sort of a lightning round. This is there's so many topics that we could discuss. But Charles, why don't you start us off on anything that you can point to? People always love hearing, of course, from the regulators, and the things that you live and breathe every day and may not seem significant to you is so helpful for all of us to hear. What can you tell us about what might be in this space on the horizon at the SEC?
Sure, happy to. Before I get started, I have to give the standard disclaimer. Like all the other government speakers, my views are my own, not necessarily those of the commission, individual commissioners, or other members of the commission staff. So one thing that I've spoken about in the past as a developing trend, I think is really kind of here to stay, is the idea of coordinated resolutions globally. I mean, we've of course had coordinated resolutions with the Department of Justice since the beginning of the program, but that trend is kind of definitely here to stay. It's not even a trend; it's just part of the landscape now. This past June, we had one which was actually kind of unique, where the Department of Justice was not there, and we coordinated with both the UK Serious Fraud Office and Brazilian authorities. That was the Amick Foster Wheeler case. And then, maybe like probably the biggest example of a coordinated resolution was the Goldman Sachs 1MDB resolution back in October of 2020, where, I mean, the number of coordinated jurisdictions on that was just tremendous. And as international anti-corruption enforcement continues on an upward trend among our partners internationally, I think you're just going to see more and more coordinated resolutions, likely with new partners that we perhaps haven't coordinated with in the past. I can't speak for the department, of course, but I think we'll see that with them as well. And it just, it's good for the program, and it's something I think for many years companies have asked for. Right? They really wanted it to happen. Mm-hmm. Hopefully they still want it to happen now that they see it in action. But that is something people can continue to expect. We're always on the lookout for new industries that may not be meaningfully addressing FCPA risk. we saw that a few years back with financial institutions. No one had really thought about financial institutions and FCPA risk, and then we certainly had a series of those. I think we'll see, not necessarily in the nearest of near term, but I think on the overall horizon, we'll see some new industries that haven't found themselves in trouble before. In this past year, there was one, we'd had earlier cases, but it's been quite a while since anything in the advertising space. And there was a WPP case this past year. So it's not a new one, but certainly one that I don't think people have been thinking about for quite a while. And the other thing, we talk about a lot, individuals are always a priority for all enforcement program areas. It's a priority in our space as well. It is a little more difficult than others just because, most of the activity is overseas, and establishing personal jurisdiction over the culpable individuals can be quite problematic or impossible in given circumstances, but it is something we're always trying to develop the cases for. And we've had some very successful individual resolutions in the recent past. So that's the small scale crystal ball.
Well, they're very much appreciated. And, it is helpful to be reminded that areas that you have focused on and emphasized in the past, don't just assume that the government is done with those and won't be potentially swinging back on those topics. So it's very helpful. I was going to ask you about a follow-up question, if you hadn't mentioned about individuals, because I noticed that certainly when the director spoke, and I believe when the chair spoke, certainly Goodrich spoke about individuals and gatekeepers quite a bit, and difficult to bring cases against individuals for the reasons that you suggested. I also noticed that while everybody talks about crypto, cyber, and ESG, that seems to be like almost a mantra, right? That when the chair spoke just briefly, a little prior to the last panel, the insider trading panel, he did mention the FCPA in that space. So I think that while some people had wondered, I think it was, and I apologize if it was the director and not the chair, but one of them said that if you focus on everything, you lose sight of many things. So, there was an interest in knowing this is obviously an important area for many of our clients because practically everybody has a global footprint, but to what extent the FCPA, was still active, and it sounds like it continues to be active.
We're still here, and we still have plenty of work to do.
Yes. Okay. Well, thank you very much. Yeah, the new industries, you're right. Financial services had not been an area where people had thought about, but it seems like what you're saying is that if you have a global footprint, FCPA could apply to your industry.
Yeah, that's really the thing. There's so many industries that I think that people, they don't have a government client, so they don't really think they have exposure. But how do you get your goods and services to market? Are you in a highly regulated industry? Like obviously, pharma is a perennial player in this space. It's highly regulated. You also have government clients, but you have your touch points, getting your goods and services to market. You have to cross borders. You may need, particular licensing, et cetera, to do business in a given country, even if, you're not servicing the government per se. So I think people really need to be mindful of what those touch points are and make sure that their compliance programs are appropriately attuned to the risks of their business. And, on an ongoing basis, always reconsider the changing business landscape.
Mm-hmm. Mm-hmm. Not be complacent with what you have in place, but it has to be an evolving process.
Yes.
Yeah. So Tarek, when the chair spoke, he talked about coordination, both globally and with other agencies. Having been most recently at DOJ, I wondered what thoughts you had in terms of cooperation and coordination between the SEC and DOJ in this space and the role it plays.
So when I was at the DOJ, we worked very closely with the SEC, and I'm still seeing it now. Now that I'm in private practice, it's typical, and that goes from meetings all the way to the end to the resolution. You're going to continue to see some enforcement actions where you have both an SEC settlement and a DOJ resolution. You'll see some where you have an SEC settlement and a DOJ declination. And you'll see some issuer cases where you've got only an SEC settlement, and for whatever reason, the DOJ closes its investigation because it couldn't prove anything beyond a reasonable doubt. Now, usually those come at the same time. Recently, there was an investigation of Beam where the SEC had a settlement and the DOJ had a resolution 2 years later. I think that's an outlier, and I don't think it was because of a lack of coordination. But that is something that companies should consider, is if you're cooperating, that you need to engage with both agencies. For example, if one agency asks for a certain set of documents, you're much better off producing them to both agencies. You want to be proactive in that respect. What you don't want is a situation at the end of an investigation where you're sitting in a compliance presentation where you're with the SEC and the DOJ, and you're referring to a certain document or a certain set of facts, and one agency is familiar with it and the other one's not. I think that's something to keep in mind. And now, you mentioned earlier statements that the director made, and you've seen sort of the enforcement priorities coming together. Both agencies are focusing on compliance. Both agencies are focusing on individuals. And SEC leaders have made some recent interesting statements about, as you mentioned, Joan, gatekeepers. And when you put that together with a focus on compliance, you may see not only more monitors in parallel resolutions, but you also may see more monitors in cases the SEC brings on its own. And we also might see more charges against in-house employees who oversaw the compliance program, the gatekeepers, as you mentioned.
Mm-hmm. Mm-hmm. Very interesting. You mentioned declinations, and I think there were 12 in 2020. Do you think that that's going to continue at DOJ?
I think it might. I don't think you're going to see a major increase. I think you're going to see either a steady increase, or I think it has plateaued and will move along at the same level. And at the end of the day, the DOJ has a public policy that they've released. If you voluntarily self-disclose, if you cooperate, if you remediate, and you do those effectively, there's a presumption that you're going to get a declination. Now, there may be some instances they've laid out a list of non-exhaustive factors like very large profits, senior executive involvement that could take you outside of that. But as we've seen with the Cognizant case, they charged the president and the chief legal officer, who was a gatekeeper, and the company got a declination. And there was also another case against ICBL, an insurance company, where the CEO was charged and the company got a declination. Mm-hmm. So I think the declinations in the CEP are here to stay, obviously, but I don't foresee a major jump in the number.
Interesting. In terms of coordination between the SEC and DOJ, obviously our clients, if you're a member of the defense bar, your clients do want, and I think the government wants coordination too, but sometimes the DOJ and SEC are moving at a different pace on something. How can you as defense counsel help? You talked about certainly sharing documents, but what about when witnesses are going in and the two agencies are not aligned in terms of timing? Any thoughts about that?
Yeah, so you can make sure both agencies understand that the other one is going to interview this person, and it'll be much easier, it'll be much more beneficial for them if they get the same statements and the same set of facts from that witness. And although sometimes they are on different timelines or the different agencies have different priorities, I haven't faced a situation yet where, for example, if somebody was going to be interviewed, where one agency didn't participate. Often, even if it's not a priority for them, if that investigation for whatever reason is less important than other ones they have, they'll still listen, and they may not be as active in the interview, but they'll still participate.
I have seen a couple instances where that hasn't happened, which creates some issues. But hopefully that will be not common. How about that?
Yeah.
So Bill, we've talked about, alluded to foreign regulators and cooperation with foreign regulators, and actually that's what the chair focused on. And I will say that while in the FCPA space, it used to be SEC alone, really, we've seen a lot of activity outside the U.S. Charles highlighted, of course, cooperation with foreign regulators, and including situations where DOJ wasn't involved. What do you see in terms of coordination with foreign regulators in this space?
So I think there's two concepts. One's coordination and one's sort of cooperation. And I think what we're seeing in terms of cooperation is a decent level of cooperation with the SEC and foreign regulators, meaning that they're helping each other get the documents they need, the records they need, the information that they need. And at that level, based on what we've seen and heard, I think there's a pretty good level of cooperation. In terms of coordination, there's been a fair amount. And as Charles said, I mean, you can look at the Foster Wheeler case, which is Brazil, the UK, and the SEC, and they coordinated the resolution. They coordinated the various amounts that were going to be paid to which jurisdiction, and I think that's definitely beneficial. You can look at activity in a whole bunch of countries, and you can see a lot more anti-corruption investigations in Brazil and South Africa, even China. And while you see a lot more activity, it's not as clear to me anyway how long or how sustained it's going to be. I mean, take Brazil, for example. I mean, I credit the Lava Jato investigation in Brazil with sort of kicking off a lot of this activity. And in Brazil, that investigation was fairly successful. They had I think about 295 arrests, 278 convictions, over $800 million in ill-gotten gains that were returned to Brazil. They've got a president in Brazil that was connected to activity and was jailed, but it didn't stop there. There's 5 presidents of Peru that have been under investigation, 2 Panamanian presidents, the former head of Pemex, the Mexican state oil company, has been charged, and he's implicated 3 presidents of Mexico, and it sort of all flows from that. So it's been successful. Brazil, the Lava Jato task force was closed earlier this year, and there's pressure from the political right because I think there was some concern that anti-corruption measures may be getting too close to the current president. The left is equally upset because the president who was jailed, Lulu, is sort of a favorite, and there's issues there. And there were allegations of prosecutorial misconduct that have sort of come out recently. And so when you put all that together, you think Brazil is going to keep going forward on this push, but you can't be certain. And the same is true of South Africa, where they're making a big anti-corruption push, but it is tied a bit to local politics, and the same plays out. You see some other countries not doing that much, and so, for example, the SFO in the UK issued their annual report earlier this year, and they indicated that 4 individuals were sentenced over the previous 12 months. They entered into 2 DPAs, one of which was Foster Wheeler, I believe. They got orders for £7.4 million, and they actually got money paid out to victims of only £220,000. And so that's to if I can channel my British, that's less than robust. And so you see a lot of signal things moving in both directions. But what's clear on the defense side, I think, is if you have a case, you're more likely than a few years ago to at least have multiple regulators from different countries looking at this, and you sort of have to adjust accordingly. We had a case where we did an internal investigation, reported the results of that investigation here in the U.S. Were very helpful and cooperative. In the foreign country, they wanted a lengthy and they would want a lengthy report. And sort of a PowerPoint presentation with the key documents and sort of a download of what was told is looked on with suspicion there. And so if you're on the defense side, you've got to think about, okay, what is going on with the various regulators? What do they want? What do they need? And how can you navigate sort of all of that?
A very difficult task, to be sure. And I had wondered, Bill, about the varying politics in the different countries and as changes occur, what happens in that space. So you had a very interesting perspective on that. It will be interesting because obviously Brazil has accounted for a lot of the foreign activity in this space. And it will be interesting that the UK has robust laws, but not always as robust enforcement. Do you pick up the phone and affirmatively call other jurisdictions? And when do you do that?
I think that's a discussion you've got to have early on, and I think it's really going to vary country by country. There are a number of countries where that's not the norm, and so you've got to figure out if this is a situation where you want to break the norm because you want to be as open and transparent with any people that may be interested in the facts, or if it's better to wait. One of the things that we've spent a lot of time doing is really engaging with local counsel in the various jurisdictions, trying to understand both the political situation, but also, okay, what are the prosecutors or what does the anti-corruption agency expect us to do, and sort of how can we navigate that?
Very good. Charles, in terms of coordination and cooperation with foreign jurisdictions, is there, obviously it's something that the SEC has been very focused on in this space, because I think there was always a recognition that if it was the SEC alone, people were going to think about, I think Chair Gensler talked about using other jurisdictions to evade regulation and that sort of thing. But what can we as defense counsel, but also what does the SEC do in terms of trying to promote cooperation and coordination with foreign jurisdictions?
Yeah, so a lot of people may not know this, but there are meetings of law enforcement officials that go on regularly around the world, where like we together with the DOJ and the FBI meet with counterparts from all parts of the country. It's interesting. While Bill was talking about South America, one of the last things I did pre-pandemic was spend a week in Sao Paulo, meeting with folks from all over Latin America, prosecutors, police, talking about ways to coordinate and ways to build these cases together, and that happens globally, and it's been going on for many years. So while there may be difficulties in any particular matter of being able to get coordination, the impetus is being built across the spectrum. So that's a big thing that we do. And without cooperation from our foreign partners, even just to gather evidence, it's next to impossible to build these cases. But it's much more powerful when you go beyond just helping us gather evidence, when we can work collaboratively within our respective systems. Just like here, in the United States, we have a very close working relationship with the department and the FBI, but they're parallel. They can't be joint. You can't cross that line. And you were talking about the witness interviews like that. I was thinking to myself, well, that's a prime example of it. It's parallel. It's not joint. We both have our own missions to further.
No, and we're reminded of that all the time. And I think that kind of came up in the director's panel today as well. True. It's nice though when a witness can speak with both agencies at the same time. Charles, your co-panelists have been in the government, but you're there now. And we all have perspectives on presentations to the government and what is effective. And what would be, I think, helpful for the listeners today is hear your, and especially in the FCPA space, there are some types of meetings that, at least from what I've seen, somewhat routinely happen, such as what I call remediation day, where you go in and you talk about the remedial steps that have taken place, because it's very important. But there's other types of compliance type meetings and that sort of thing. And then there's also meetings, of course, where you discuss the underlying violations. You can talk about those all together or separately, but what do you find to be most effective when people come in, or persuasive?
Sure. So not to offend the co-panelists, but the absolute worst thing for a compliance or remediation presentation is for it to come from defense counsel.
And I think to be blunt, we actually advise our clients of that because we recognize that. Yeah. So of course, no, we understand that. So here from the entity itself, right?
Yeah, we want to hear from the people who are actually in the business in those positions. So if it's a compliance presentation, I want to hear from hopefully the chief compliance officer. I want to hear from people with regional compliance responsibility, people who can answer questions in real time. I've done X, Y, and Z. Okay, why do you think X, Y, and Z works? What was your thinking about that? What other things did you consider? How is it working in practice? Things that defense counsel can't even possibly respond to, because, they're not doing it. These are the people that are doing it. And if you want to persuasively inform the government of what you're doing, particularly if maybe you're on the cusp of a situation that may call out for a monitor, but for significant remedial steps haven't been taken, it's critical that you have those people there so that we can assess their credibility, knowledge, commitment to it, as well as respond to questions in real time. The other types of meetings we were talking about were, I want to say they're more in the ordinary course, but if you're talking about, issues of law, who else are you going to talk to about that except for defense counsel? What is the relevant case law that's out there? What may come to bear? It's not necessarily helpful when defense counsel tries to tell us how we should interpret the facts. Obviously, we always need to be open to the possibility of a different interpretation, and it can be helpful from that dialogue to be reminded of that if necessary. But ultimately, if defense counsel is coming in and saying, we think you should see it this way, but if you saw it your way, we think this is the appropriate outcome, as opposed to being wedded to what may be a very narrow interpretation of the facts from our perspective, helps the dialogue go much better.
What do you find, and you maybe touch on that, but what is the least effective?
The absolute least effective is to come in and read me a PowerPoint.
Yes. That's interesting. I know I have said to some clients in the past, you cannot read from notes. So I think that's what you're affirming there. Tarek and Bill, in terms of these meetings, they are, as Charles has just said, I mean, it can make the decision regarding whether there's a monitor or not, which is a big deal for our clients. Is there any particular points you want to make in terms of what you have seen when you were in the government, or now that you're in private practice, how you advise clients on that? Tarek, why don't we start with you?
Yeah, and I agree with what Charles said. And part of the reason you want to hear from the company's compliance team is that they're going to be there after the law firm leaves. If you keep a resolution, you're still going to have self-reporting obligations, and the law firm's still going to be involved, but they won't be as hands-on as they were during the investigation. You need to understand that the people who are running the compliance program are invested in this. They understand what the root cause of the problem was, and they can explain it to you in a few sentences to make sure that they get it and they have fixed it, and they're going to make sure it doesn't pop up again. And with factual presentations, one of the things I used to do is I'd try to, get a handle from defense counsel. If they would call me and say, what are the issues? I would explain to them, look, here are the issues that we think are important. Here are the ones that aren't. Because one of the things that was frustrating is if you set aside, say 3 hours for a factual presentation, and they plan to spend half that time on facts that you don't really think are either important or, as Charles hinted at, really in dispute. And one of the things that's important, you can't hide from bad facts as a defense attorney. If you have them, you have them. You have to explain why they're less important, or explain why, they may fall outside the legal issue. There's a law here because we've got complicated issues, especially with jurisdiction. Then that may be the issue that, where you get the government to understand that, look, this isn't really a case you should bring.
And I think the director mentioned taking on head on the problematic facts. If you come in, he was talking about Wells meetings, but no, that's important. And so I think sort of tying what you're saying together with what Charles was talking about, it might be that, if you had bad facts, but you've remediated or are in the process of remediating, it's important to point that out. And sometimes the remediation isn't complete. I think it's important to be upfront that when it's still a work in progress. Yeah.
I agree with that. And you can, I think, effectively, with both the DOJ and the SEC, be absolutely honest about this is where we are in building this program, and here are the steps, and here's how we're going to get there, and here's the commitment that the company has. The other thing I was going to say was for the remediation day, I completely agree that it really needs to be the client and not the lawyers. But the process to get ready for that, I think, starts much earlier than a week or two or a month out.
Oh, yes.
And in a long-running investigation, it could be a year out where you say, gee, okay, we're going to have this day at some point coming up in the months ahead. Here's what we're going to have to talk about. Let's make sure we've actually built something that's effective, that's going to look to be effective. And let's see where the holes are and the gaps are, because if we don't do that, certainly Charles and his team is going to sort of point all the defects or issues out. And so I just think that process is going to start pretty early.
Yeah, no, it is. Bill, for me, that process starts really at the end of the internal investigation. Once you've started at least to identify where the problematic areas are, you need to really start thinking about what the remedial steps are going to be and how you're going to present that. Sometimes, what about sending in the most senior person versus sometimes in a large corporation, you have the most senior person, but then there's the person that's like on the ground. And sometimes the government will ask like, okay, X comes into you, how do you handle it? What do you think in terms of the more senior person versus the person who's going to be maybe not the lowest level person, but more day to day?
If you're talking about trying to avoid a monitor or to get a resolution that from the defense side makes sense, I think you've got to have both. You can't make it a circus where you have sort of a parade of people coming through. Although having said that, I think I've done that. I do think kind of having both and really, I think this is the point where there shouldn't be any advocacy necessarily by counsel. There's an opportunity after the meeting to have some advocacy, before the meeting to sort of set the stage, but you kind of just have to, with a fair amount of preparation, you've got to just lay it out there so that the staff can see, yeah, the senior people are committed and they're providing the resources, and the people on the ground are actually doing this and they're following through.
So, Bill, staying with you, obviously cooperation is very important. Obviously, it means more than just responding to the subpoena. What is the actual and we've heard now for chairman after chairman, director after director talk about it. What is the calculus in terms of self-reporting, and what is the because that's one of the 4 pillars of cooperation, right? Self-policing, self-reporting, cooperation, and then remediation. We've talked about remediation, but And the SEC has tried, in the prior administration, I think, to make a distinction between having a bigger carrot and what I call a bigger stick. But is it always true that self-reporting and is the right way to go? Does it impact the outcome for defendants?
It can make a difference, certainly can make a difference. And when you're looking at the case from the beginning, you may have a case, it sort of falls into a bucket where you can see sort of a very good result at the end. If there's self-reporting and there's sort of the maximum level of cooperation, maybe there's no charge, or maybe there's a charge without a penalty or a much reduced penalty. And there are other cases where, it's a tougher, I think it's a tougher call, because when you're thinking about self-reporting, not self-reporting, to me, it's the difference between self-reporting and cooperating. Because if you're not going to cooperate, I'm not really sure you want to self-report. But it's also the difference between if you don't self-report and it comes out, still providing complete, fulsome, maximum cooperation. And so, is there a difference between those two? And I think there can be. There's certainly. It's certainly possible. I mean, I think in the age that we live in now, especially since the comments in the last couple of weeks from people at DOJ on more monitors potentially, and I think it's probably it tips the scale a little bit to say, yeah, you may want to self-report and try to get that benefit if you can. Try to distinguish yourself so that you're not facing a monitor. I mean, companies. I mean, I think Charles would say, and I think I would agree, at least in part, monitors are a great way to ensure corporate compliance. From the company's perspective, they're extremely costly, time-consuming. I once had a client who said when he came back in another life, he wanted to come back as a monitor because of the financial reward.
We've all missed the boat. We've all missed the boat, Bill. Yes.
So yeah, I think that could make a difference there. And if you think it could make a difference with the DOJ, which it possibly could, depending on the facts. But those are the two factors I think that can sort of weigh things. If those weren't an issue, yeah, I think there could be some benefit. But I don't know that the penalty for, if you're going to provide fulsome cooperation, if there's an investigation and you've remediated in real time and you've fixed everything, there's a difference, but I'm not sure it's meaningful.
Yeah. Tarek, everybody just looks at the cases that come out and they say, oh, this was this administration. Obviously, people work on investigations for a long time. And I know there's a lot of movement in the government to speed that up. But we've just been through the pandemic. And while the SEC has been doing, there was this minor moment where we all thought that this was going to blow over in a month or two. But almost immediately, the SEC started doing remote testimony and that sort of thing. Interviews, so that really the investigations, from what I can see, really didn't hold up. However, in the FCPA space, there are rules against certain countries. China, it's very hard. The SEC can't just do a WebEx interview or DOJ report. Right. So what impact do you think it'll have in the FCPA space as we look down the road? Maybe not what the commission or DOJ want, but what impact do you think it will have in terms of cases that are brought?
It will have an impact. The question is, when will we feel it and how big will the impact be? I think it's unfair to expect the SEC and DOJ to proceed as normal in the pandemic, especially in these kinds of cases that take years. I just, from what I've seen, they've done an excellent job adapting, like you mentioned, taking testimony virtually, doing witness interviews virtually, effectively managing company presentations. And in some ways, it's been easier to schedule meetings because you don't have to worry about people flying in, spending a whole day or two for a 3-hour meeting. But in these investigations that take years to begin with, and they rely on cooperation from foreign governments, and they rely on companies that are cooperating to be able to get evidence overseas, to interview people overseas. There are going to be problems doing that. And again, since these take several years, there's going to be a time lag in terms of when the pandemic happens and the effect that it has until you see the effect on the number of DOJ resolutions and SEC settlements. And then if you look at that same thing from the company's perspective, from a compliance perspective, as your business changes, your risks will probably change. And as your risks change, your compliance program needs to change. Budget cuts need to be determined by your risks and the changes to your risks, not by your overall budget. And this is a situation where tone at the top and tone throughout are very important so that people at the company understand, look, we can't cut corners. We can't ignore compliance because there's a crisis. For example, you may be onboarding new third-party intermediaries. It may be more difficult to do effective due diligence. And if you can't do it now, once the pandemic ends, you're going to have to go back and make sure you do it. Training is more difficult. Interviews are more difficult. People may feel isolated. And going back to what you talked about with self-reporting, if you don't have an effective compliance program and people don't feel connected to the company, you may see an increase in whistleblowers. And if you've got an internal whistleblower, then you have to go back to that decision you were talking about right, whether to self-disclose. And you need to understand you can be an ethical, responsible company without self-disclosing misconduct. You do, however, need to make sure that you remediate, because if you have a problem and you don't disclose it and the problem continues and the government finds out later, it's going to be much worse for you than if you had either self-disclosed it or if they had found out about it in the beginning.
Really good advice. Really good advice, not just in this space, but in others as well. And it is all about risk and managing risk. And when you see a problem, dealing with it. Really good advice. Charles, one of the accomplishments during this pandemic time period was a revised manual came out in the FCPA space, the joint SEC DOJ manual. And do you have any comments or highlights on that? I will tell you, when the first one came out, I thought, well, it kind of just summarizes the area, but I found that actually it was enormously helpful to clients to be able to point to it. So this revised version, what pearls of wisdom do you have on that?
Well, I'm glad to hear that your opinion on it turned around. The resource guide was supposed to be just that. As you say, kind of laying out the landscape that for anyone who practices in this area, it's like, oh, of course, I knew that. But for everybody else, including potentially, companies and individuals who are first facing an investigation, it's news to them. So, the update to the resource guide included some changes to case law. So on the SEC side, it captured both Kokesh and Helou by the time of publishing. On the DOJ side, significant for them was the Hoskins case, US v. Hoskins. So the guide covers that as well. I think there's some editing for better clarity throughout it on all the areas. Some updated case examples that were made to the guide. So there's no sea changes. And other than, significant judicial decisions, it was more of an incremental update.
Well, I will tell you, I know that it takes an enormous amount of work to put together such a document. And I know that it is appreciated both by the defense bar and by our clients as well. And it really is an enormously useful guide for everyone. So thank you for that update. Bill and Tarek, I know that there's going to be a panel on whistleblowers, but we've kind of touched on that. And I think that affects the reporting decision as well. What do you see as Tarek, what do you see as the impact of whistleblowers in this space in particular?
I've seen that even small companies are setting up whistleblower hotlines because they're becoming more attuned to the risks that whistleblowers can create. One advantage of a whistleblower who reports internally versus someone who goes straight to the government, if they report internally, there's a good chance that they want to see the problem fixed And if you make the person, even if it's someone who reports anonymously, if you make them feel like you understand the problem and you are addressing it, they're much less likely to then go to the government. And one advantage is they can help the compliance department understand holes in the compliance program, potential problems that they didn't anticipate that they can then fix. And one thing to keep in mind is you need to make sure if someone reports that there is not just, they're not retaliated against, but there is no appearance of retaliation. Because if that happens, then the person may sue you, you get a much bigger public relations hit, and the DOJ and SEC are more likely to investigate you and to question your commitment to compliance if they're seeking a resolution.
Well, my understanding is whistleblowers, there's a whistleblower in practically every major case the SEC brings. So that process is worthy of a separate panel, Bruce. And I see that you're on. That means we're at our end.
That's a great idea. We should have a separate panel. I hereby declare we will have a separate panel later on today. Thank you, Joan. Terrific job. And Tarek, Charles, Bill, thank you all for a great session. And the next panel is on managing internal investigations and advanced government defense. Very interesting panel. It'll be at 3:15. So we'll see you in 5 minutes. Thank you.